and I have given about the overview, what are the law governing IPs and what is the meaning and what are the types of intellectual property. That is the patent, the trademark, the copyright, we all know. And here we are going to have a brief discussion about that and what are the infringements. Yes, very important one, and then case studies, and we are going to conclude. So WIPO, it is actually the World Intellectual Property Organization, which was established by the WIPO Convention in 1967. And WIPO is actually a specialized agency of the United Nations. They promote the protection of IP throughout the world. They promote. And their headquarters are in Geneva, the Switzerland. It is available there. And the World Intellectual Property Day, it has been celebrated on April 26 every year. And this is the older one. I am taking it and just giving a glimpse of it. World Intellectual Property Day, which of April 26. And what are they focused to promote the visionary innovation as the key to a secure future? They are focusing on the visionary innovation. And coming to India, intellectual property law in India, what does it state? There are many big and small intellectual property law firms worldwide, like in India, USA, UK, Chicago, etc. They provide a qualitative help to inventors and the creators of the product. In India, the intellectual property rights are safely protected and also controlled by well-established statutory and judicial framework. We have an awesome statutory and judicial framework. Apart from that, there are many attorneys and law firm on intellectual property in India in various states. We have. So what is intellectual property? An important one. It is a property that arises from the human intellect. It is our own property. It is our own creation. It is our own invention. So it is a product of the human creation. And it is going to comprise of two distinct forms. Two distinct forms we have. Number one is the literary and the artistic works. And number two comes the industrial property. These are the two things. They are going to comprise of two distinct forms. And it is a wonderful product of the human creation. And this human, they hold its rights. So we call it in Indian patent rights. And with this example, I feel I'm going to give you a thorough description about the patent, the trademark, and copyright, I hope, with this example of a car. So when we take off this car, and when we talk about the car's working mechanism, yes, we talk about the working mechanism of the car, we can state it as a patent. Yes. And when we talk about the name of the car or something related to that, it comes under the trademark. And the manual of the car, yes, it comes under copyright. And the car is going to have its unique shape. That is going to be the design. I hope I have made very clear. I hope the working mechanism falls under patent. The name of the car falls under trademark, and the manual takes up the copyright. And literary and artistic works, it could be of books, paintings, musical compositions, plays, movies, radio or TV programs, performances, and other artistic works will going to be protected by copyright. They have their own protection with the help of the copyright. An industrial property, it describes a physical matter that is the product of an idea. Yes, the idea, and that idea is made as a product, or it could be a concept for the commercial purposes. And how are they going to be protected? They could be by patented objects, by trademarks, by industrial designs, by trade secrets, by layout designs, by geographical indications, by anything. The geographical indications also is a very important one. For example, we used to say about the Kolhapuri Chapel. Hope you all would have known Kolhapuri Chapel, something like that, Malgova mango. So these are all is the geographical indications. And they are going to be protected by all these things: patented objects, trademarks, industrial design, trade secrets, layout designs, and geographical indications. So what are the major types is the functional and technical invention. They falls under Patents Act. The purely artistic works fall under Copyright Act. And the symbol, a logo, any word, any sound, color, design, they falls under trademark. And all have the amended act and the following years. It's given 1917 amended in 1999 and 2005, and Copyright Act 1957 amended in 1982, 84, 92, 94, 99. And Trademark Act is 1999 and amended in 94, 96, and 2000. Yes, it's a very important picture. If you don't see a problem with this question, you need the class. Yes. So what he is asking is, all I asked was, can I patent my copyrighted trademark? My God. Yes, patent is entirely different from copyright and trademark, isn't it? So what he is asking is, all I asked was, can I patent my copyrighted trademark? Yes. So patents, it is going to be covered under the act called Patents Act 1970, and which has been amended by 2005, the Patents Act. It extends to the whole of India actually, and it shall come into force on such date as the central government may publish by notification the official gazette. It could be notified when the thing is got notified. From that day onwards, it gets counted. A patent describes an invention for which the inventor claims the exclusive right, for which they are going to claim the exclusive right. An invention is going to be patentable if it is going to be new, if it is going to be useful and not obvious, pertains to patentable, and subject matter. All are important. It should be consisting of all these points: a new novel one, a useful, not obvious, pertains to patentable, and subject matter. Patentable subject matter. Yes. The invention, it relates to a process or a product, could be both. Yes, the invention could be related to a process or relative to a product, or at times both. And it involves an inventive step. It should be capable of industrial application, might be a mission. So the life and duration of the terms of the patent is 20 years from the date of filing. For all types of invention, whatever may be the types of invention, the term of the patent is going to be 20 years. The priority date, the first when we file. The date when we file, from that the priority date counts on. The date of the patent is the date of filing the application for a patent, and the term is counted from this date onwards. The fee for filing patent is, government fee for filing a patent application is rupees 750 for individuals and 3,000 for the legal entities. And for the first and second year, no fees is charged. And renewal fee is there on the yearly basis. And it should be required to be paid for third to the 20th year for keeping the patent in force. To keep the patent in force, we need to pay the renewal fee from the third year till the 20th year. The patent lapses if the renewal fee is not paid within the prescribed period. If it is not paid within the prescribed period, the patent lapses. It's a very important question, I hope. Is a patent granted in one country enforceable in other countries? Something like that. There is nothing like a global patent or a world patent. Patent rights are essentially territorial in nature. They are going to be territorial in nature, and the granting a patent in one country of the union does not force other countries to grant patent for the same invention. Yes, it is not possible. When it is granted in one country, we cannot take as such. This should be granted in all the other countries. The same goes for the refusal also. Granting and refusal both takes the same thing. The refusal of the patent in one country does not mean that it will be refused in all the other countries. No, not such case. Granting and refusing in one country will not have its force on other countries. Patent holders in India. The list of top 10 patent holders in India, they comprise of the pharmaceutical and biotech companies. In India, 184 patents are held by the Council of Scientific and Industrial Research, followed by Ranbaxy. They hold 184 patents. While the top 10 patent holders across the world are IT companies, and very sorry to say in India, no IT firm has the patents. And we can meet here the youngest patent holder, and we are very proud to say he's an Indian. He's the youngest patent holder who is sitting on the wheelchair. He's from Jaipur. Drawing inspiration from scientist Stephen Hawking, the wheelchair-bound 9-year-old boy here has invented a game of 6-player circular chess. He has invented it, a 6-player circular chess. The boy, Rideshwar Singh Bhati, has got the game's design patented in his name. He has got the game patented in his name. Very proud to meet him. He has innovated a 6-player circular chess. And this is how the patent will look like. The patent certificate will look like. And coming to trademark. So it is covered under the act called the Trademarks Act 99. The act came into effect on September 15, 2003. It replaced the Trade and Merchandise Marks Act 1958. It extends to the whole of India. It shall come into force on such date as the central government may publish by notification in the official gazette. Stands as same. Same as a patent. When we file, from the date of filing, the date counts. The date starts counting. And the trademark, it could be of a symbol, a logo, word, sound, color, design, or other device that is used in identify a business or a product in commerce. It could be of a symbol, it could be of a logo, word, sound, or color, or design, or any other device that is used to identify a business or a product in the commerce. The different symbols we have, these 3 symbols we have. The first one, it intend to use application filed for the product. And this one, it is for filed for services. And this is going to be a registered trademark. It is going to be a registered trademark. You have all these stuffs, registered trademark. So it stands for the product, and this stands for the services, and this is going to be a registered trademark. And what are all the registration procedure we need to follow? The application for search, and we have to find the application for registration, and the examination of trademark, advertisement of trademark, filing of the opposition, and finally the certificate issued. And we have to find the application for the search, and we have to find the application for the registration, and we have to examine the trademark, and we have to advertise the trademark, and filing of opposition must be done. And finally, when all these steps we gone through, we receive a certificate. The duration and the fees of the trademark is valid for 10 years from the date of application, which may be renewed for further period of 10 years on payment of the prescribed fees. Yes, it is valid for 10 years. Yes, from the date of application, and which could be renewed for the further period of 10 years on payment of the prescribed fees. When we pay the payment of prescribed fees, we can extend further for another 10 years. The service mark right or reserved exclusively for owners for 17 years, and it can also be renewed. Could be done. The government fees is rupees 2,500 for each class of goods or services. A trademark is actually a sign which is used on or in connection with the marketing of goods or services. Used on, yes, used on. The goods means that it may appear not only on the goods themselves, but on the container or wrapper in which the goods or when they are sold. That is what we say as used on. Set apart from the surrounding text, the correct usage of Raymond textile is this one, Raymond textile. This is the way they give. The font style and the font color will be like this, Raymond textile. It is India's leading producer of the worsted suiting fabric with over 60% market share. And Raymond Textile is India's leading producer of the suiting fabric with over 60% market share selling. And we can find out this one is the incorrect use. It is the incorrect use. And this is the correct usage. Yes, this is a trademark. And specifying of the font, its size, its proportion, and how it is placed, everything is mattered in trademark. We can see the Vimal. It looks like this. This is their trademark. And this is going to be the incorrect usage. And about ADT, this is the incorrect usage. And about this. Yes, with this, we can say about the trademark, how it should look like. And spelling must not be changed. Yes, again, spelling should not be changed. For example, we can see the correct usage and the incorrect usage, Calvin Klein and Tommy Hilfiger and MPC Potteries Gwalior. So it should not be this case. These are all the incorrect usage. And here we can see about the trademarks further. We have a Coca-Cola bottle here. And this is the name, how it is should be. And this is another logo type. This is the logo type. It will not be changed. The symbol and the slogan, I'm loving it. That also will not change. And the shape of the bottle, that is also a trademark. And coming to the color, the orange color, the color what they use, it's a trademark. The name, the logo type, the symbol, the slogan, the shape, the color are going to be the trademarks. And we come on to the copyright. The Indian Copyright Act 1957 governs the system of copyrights in India. They govern the system of copyrights in India, and which is going to be amended in all these years, 82, 84, 92, 94, and 99. The meaning, it is a right which grants protection to the unique expression of ideas, how they express, not the idea, how they express the idea. The idea will not come in copyright. The expression of the idea is a copyright. We see all the films, isn't it? Films and songs and whatever it may be, everything comes under copyright. They doesn't mean about the idea. They mean about the expression of the idea, which is going to be copyrighted. So the term original in the copyright law means that the work originated from the author. There is no requirement for the novelty or uniqueness. As there is in patent law, these novelty, uniqueness, they comes for patent and not the copyright. The copyright law protects the expression of an idea, how the idea is being expressed, not the idea itself. It doesn't mean about the idea. They mean about the expression of the idea. So what and all will be covered by copyright? The literary, the films, the dramatic things, musical, artistic, sound recording, these are covered by copyright. And what is not covered? The ideas, the facts, the recipes, works lacking originality, for example, the phone book, and names, titles, or short phrases, these are not covered by the copyright. What is the registration procedure for copyright? Register a copyright by completing a simple application form we have, and along with it, we need to pay the appropriate fee. And send the copy of your work. It may appear with the same title, but if each work has been created independently, Each will have its own copyright protection. Each should have its own protection, copyright protection. And the duration of the copyright is the author's lifetime. Yes, it is going to be the lifetime of the authors. And after that also, plus 50 years. Yes, author's lifetime plus 50 years it is adding. And from the end of the calendar year in which the author dies, it starts from the end of the calendar year in which the author dies. From that, it's get counted for another 50 years. And 50 years for films and sound recordings. And it will be for 25 years for the typographical arrangements of a published edition. And the copyright protection always expires on December 31st of the last calendar year of the protection. It expires only on December 31st. Yes, we have seen patent, the trademark, the copyright, and now we can see about the fair usage, how we can fairly use it. It gives permission to use the copyrighted material if certain criteria are met. If certain criteria are going to be met, we can give permission to use the copyrighted materials and protects the freedom of speech. It promotes public benefits like education. Yes, for educational purpose, we can use. And we have to beware the fair use excuse. Sometimes we need to be beware of the fair use excuse also, and never assume that your use falls under the fair use exception. We are not supposed to assume that. Saving money is not a sufficient excuse. No, we cannot say that. And laziness can be a trap at sometimes. Yes, it could be a trap. So how much could I use actually? The photos and images, when we are using these things, up to 5 works from one author we can take. And after 10% or 15% of the work, whichever is less, from a collection, from all the collection, 10% to 15%. And when we see about the database information, up to 10% or 2,500 fields or cell entries, whichever is going to be a less one, whichever is less, we can go accordingly. And when we are doing infringement, what is it action taking against the infringements? And what constitutes infringement? So any reproduction or any use or distribution performance, etc. of the work without the permission of the owner, we call it as the infringement. If you reproduce that, if you use that, or if you distribute or perform anything that without the permission of the owner, it comes under the infringement. An identical and substantial similar reproduction is also covered. Yes. If you reproduce the identical one or the substantial one, everything comes under the reproducing of one is also covered. The infringement is the damages, is the injunction. So what are all the remedies for patent infringement? If it is done, what are the remedies? A suit can lie in the district or high court. It may issue an injunction either to prevent the infringer from any further use. Yes, it is used. The infringer has been caught, and we can prevent from any further use, and we can award the damages to the patent owner or will pay the patent owner royalties for further use. For further use, he has to pay the royalties. The Apple sued HTC over iPhone patents. The Apple sued phone maker HTC and has filed a complaint with the US International Trade Commission alleging that the Taiwanese company is infringing 20 Apple patents related to the iPhone. Yes, they have infringed a complaint. And Steve Jobs, Apple CEO, said in a statement, "We think competition is healthy, but competitors should create their own original technology, not steal ours." This is the statement given by the Steve Jobs. Competition is healthy, everybody agree, but the competitors, they should create their own technology, the original technology, and should not steal us. The remedies for the trademark infringement. What are all the remedies for the trademark infringement? Again, the suit can lie in the district or the high court, and punishment extends from 6 months to 3 years. A permanent ban on engaging in commercial activities. They will be banned permanently from engaging in the commercial activities. They might be banned. An example of a successful civil enforcement action are 3 suits filed by Adidas Solomon AG, the Delhi High Court, against the counterfeiters. He has filed. At the initial stage, infringing goods were seized by the local commissioner at the start. Cases were decreed recently, and damages of rupees 15 lakhs was awarded to Adidas Solomon. They have awarded him. And what is the remedies for the copyright infringement? Trademark, okay, we have seen. Patent, yes. And what about the copyright infringement? A suit can lie again in the district court or in a high court. 63 of the Copyright Act 1957. It will be punishable with imprisonment up to 3 years and fined as per the claims. It could be fined as per the claims. It could be fined also. The copyright claims on the basis of underlying artistic works. For example, the Ritika Limited versus Ashwini Kumar. Here they have made a duplicate of it. The Ritika Limited versus Taina Talukar and the Ritika Limited versus Sajid Mubin. They have made a duplicate of the original one. This is the copyright claim. But I didn't know what is that called innocent infringement. Sometimes we used to say innocent infringement. It occurs when the infringer was unaware that things were protected. They are not aware that these things are protected and we should not use it. They are unaware. And no excuse if work properly displays patent. Even when they say like that, they will not be excused when the work is going to properly displaying as patent and with the trademark symbol we have seen. All these R, T, M, and SM. And copyright notice as C, and it will have the name continually with the year it continually have. For example, Utsav Saris, copyright 2011-12, it will be there. If it is clearly mentioned, we cannot say it as an innocent infringement because it clearly mentions all these steps. If it is going to mention all these steps, we cannot say it is an innocent infringement. We cannot take in that case. So I want to conclude with this, and I have some more to say about the sections 3 and 4. And with this, what I conclude here is we have to create ourselves rather than using others' creation, and do not use a competitor's mark in such a way that it harms competitor in an unfair way. Yes, we shouldn't do that. And no comparisons that are likely to cause confusion. No comparison should be made. And technological advancement made the job of the creator easy, actually, yes. It also made the job of the copier also easy. Hope you all agree with me. The technological advancement, it has made the job of the creator more easy. Simultaneously, for the copier also, it made more easily. So the industrial application, it means capable of being made or used in any kind of industry. Yes, it could be made or it could be used in any kind of industry. And we want to see about the exclusions, very important part. When we think about patent, we need to see about the section 3 and 4 exclusion, where section 3 comprises of many things. And section 3A, it states the frivolous inventions contrary to well-established natural laws. For example, machine that gives more than 100% performance. Not possible, isn't it? And perpetual mission. So all these are not possible because they are contrary to the natural laws. It is an exclusion. And section 3B, the commercial exploitation or primary use of invention, which is contrary to the public order or the morality. It should not be. So it will be excluded. If we file any patent or any novelty idea regarding this, it will be excluded. We have to look on to all these sections. Section 3, it will be available in the IPR portal. You can see, and we have to be very careful in noting down all these stuffs. Section 3B, it states that the commercial exploitation of the primary use of invention. For example, the gambling mission, you're not supposed to do. And device for housebreaking, no. It is not a morality one, yes. And section 3B, it states the commercial exploitation or primary use of invention which causes a serious prejudice to the health or human or animal or plant life or the environment. For example, the biological warfare material or device, the weapons of mass destruction, a terminated gene technology, embryonic stem cell. So all these are the example of this one. And the checks and balances again, section 3B, it excludes the patents on GMOs, exploitation of which could be contrary public order or morality or prejudicial to human, animal or plant life or health. For example, affect only genetically modified microorganism, that we call it as a GMO. Genetically modified microorganism which do not fall under section 3B or patentable. It cannot be patentable. And section 3C, it states the mere discovery of a scientific principle or the formulation of an abstract theory or the discovery of any living or discovery of living or discovery of non-substance occurring in nature. For example, the Newton's law, superconducting phenomenon, and the property of certain material to withstand the mechanical shock, and discovery of microorganism, and discovery of natural gas or mineral, it comes under section 3C exclusions. It is not will be able to avail. And excludes naturally occurring microorganisms. The effect is genetically modified microorganism, however patentable. GMOs are patentable, but the natural occurring microorganism is not patentable. And section 3D, the mere discovery of a new form of a known substance which does not result in the enhancement of the known efficacy of that substance already which is existing is not possible. The mere discovery of a new form of a known substance what we have already, just the enhancement is not possible. For the purpose of this class, we can emphasize as salts, esters, ethers, polymers, the metabolites, the pure form, the particle size, isomers, mixture of the isomers, complexes, combinations, and other derivation of known substance, which shall be considered to be the same substance again unless they differ significantly in properties with regard to the efficacy. An example, crystalline forms of a known substance, we cannot say because it already exists. The salts, esters, yes, we can also say these never be patentable, never be patentable. For example, a new use of aspirin for heart ailments. Yes, aspirin is already known. A new use of aspirin for heart ailments and mere new uses of neem, we cannot take into account because these are all already known. And section 3, the substance obtained by the mere admixture resulting only in the aggregation of the properties of the components thereof for a process for producing such substance. For example, a combi flame. Yes, it is a paracetamol and the brufen, antipyretic and analgesic, solution of a sugar and color additives in form to form a soft drink. Yes, a mixture resulting into synergetic properties of a mixture of ingredients, however, they may be patentable. The soap, the detergents, the lubricants, etc. And these comes under the section 3 exclusions. Section 3F, the mere arrangement or rearrangement or duplication of the known devices. Yes, only the arrangement or the rearrangement or we duplicate, each functioning independently of one another is a known way. For example, a bucket fitted with touch, an umbrella with fan, a clock and radio in a single cabinet, a flour mill provided with sieving. Yes, these are all excluded. Section 3F exclusions. Section 3H, the method of agriculture or horticulture. For example, the cultivation of algae, or producing new form of a known plant, preparation of an improved soil. However, agriculture equipments are patentable. When we find a new agriculture equipment, a machine, those are patentable, whereas these are not patentable. Section 3I, any process for medicinal or surgical or curative, prophylactic, diagnostic, therapeutic or other treatment of human beings or a similar treatment of animals to render them free of disease or to increase their economic value or that of their products. For example, a removal of the cancer tumor, removal of dental plaque and caries, surgical processes relating to therapy, method of vaccination, blood transfusion. These are all the example we can highlight. However, the treatment performed on tissues or fluids permanently removed from the body. Yes, and surgical, therapeutic or diagnostic apparatus or instruments, when these are done, they are patentable. Yes, the machines, they are patentable. And section 3J states that the plants and animals in whole or any part thereof other than microorganisms, but including the seeds, the varieties, and the species, and essentially biological process for production or propagation of plants and animals. Not possible. The plants and animals in whole, the parts of the plants and animals, seeds, the varieties and species, essentially biological process for propagation or production of the animals and plants. Excludes the patents on all these things. For example, the clones and new varieties of plants, a process for production of plants or animals if it consists entirely of natural phenomena such as crossing or selection, and the essential biological processes. And section 3K, what it states, the mathematical method or the business method or algorithms or computer program. These are all section 3K exclusions. For example, a computer program by itself or as a record on a carrier. However, if you find any new calculating machine, a combination of hardware and software, these could be patentable. Yes, these could be patentable. And section 3L, a literary, a dramatic, musical or artistic work or any other aesthetic creation, including the cinematographic work and television product, these subject matters, they fall under copyright. Yes, we are known of it. 3M, a mere scheme or rule or method of performing mental act or method of playing game. These are all the exclusion. For example, scheme for learning a language, method for solving a crossword puzzle, method of learning a language, method of teaching or learning, they do not come under. However, a novel apparatus, if we make for playing game or carrying out a scheme, a novel apparatus is made, it is patentable. The presentation of the information, section 3N. Any manner or method of expressing the information, whether by spoken words or visual display or symbols or diagrams or information recorded on a carrier, it falls under section 3N exclusion, cannot be patented. Section 3O, topography of integrated circuits. For example, the mask works, the circuits layout cannot be patented. Section 3P, the inventions which are traditional knowledge or an aggregation or duplication of known properties of traditionally known component or components. For example, a traditional knowledge already in public domain. Wound healing property of haldi. Yes. However, any value addition using traditional knowledge leading to a new process or a new product which is novel with inventive step and industrial applicability, if is there, it is patentable. The extraction of the azadirachtin from neem can be patented. Yes, it is could be a way of patenting.